The Honorable, the Supreme Court.
Good morning, everybody. Thank you very much. Please be seated. And call the case.
Good morning, Your Honors. The matter before the court today is the case entitled In Re Windham Windsor Housing Trust J.O. Appeal, case number 24 AP 079. Representing the appellants, Deborah Lazar and Laura Campbell, is Harold Stevens. Seated at counsel table with Attorney Stevens is appellant Laura Campbell. Representing the Appellee Natural Resources Board is Melanie Keene. Representing the Appellee Windham and Windsor Housing Trust is Matthew Green. Appellees will be splitting their time.
Okay, thanks. Thanks very much. Counsel for the appellant will hear from, and if you would, counsel, please, for the record, identify yourself and your client and then proceed.
Good morning, Your Honors. Harold Stevens for the appellants, Laura Campbell and Deborah Lazar, neighbors of the project, Windsor, Windham Windsor Housing Trust. This case involves plans for a mixed-use development project in the heart of Putney, near the Putney, what's been the Putney Green. If you get off Exit 4, go down Route 5, right on your left, there's the Putney Co-op, which I like stopping at all the time. They've got really good food, by the way. But anyways, this is a nice green space. It's currently used for a garden. My clients are neighbors. They've been very concerned about the development in the area, the type of density that's being planned here. And what was planned and permitted initially by the town is a 25-unit mixed-use apartment building on Lot A1, and across with 25 parking spots, and across the town highway, the town owns, is Lot A2, where they planned 15 parking lots for overflow, which is part of the project. So after receiving their DRB permit, they proceeded to see whether or not they were subject to Act 250, and they tried to get an exemption from Act 250 under the Priority Housing Project exemption, which is 10 PSA 6001, subsection 35, provides that for priority housing, you're exempt from Act 250. But they define priority housing for these projects as the properties must be contiguous tracts of land, single tract of land. And so our argument has been that this is not a single tract of land or a contiguous tract because it's divided by
Mr. Stevens,
town road.
I'm going to ask you a question. Does it make a difference that the town, for tax purposes, considers it a single parcel?
No, and because the town tax purposes, we all know, doesn't create title. Tax maps don't create title. The towns do this just because it's simple, and from the town's perspective, that may be the case. But in this case, the legislature made quite clear that the lots must be contiguous. So I had no doubt that towns do this all the time, where they merge parcels, even though they might be just divided by a street or a right of way.
Mr. Stevens,
one parcel.
in Route 4 Association versus Sherburne Plan, we held that a looser meaning of contiguous may be appropriate based on legislative intent. Seems that the legislature has clear intent these days to want to develop housing on all levels for individuals. So how would you distinguish that case from this one?
In that case, I think you might have found more ambiguity in the law. No, in other words, I believe your jobs as justices is to interpret what the legislature wrote. And if there's plain meaning, legislature was clearly stated, as they did here, that the lots must be contiguous tracts.
But this case basically said that there is no plain meaning to contiguous. It kind of depends on the facts and the intent of the
Well,
legislature.
then I think you should consider reversing that case because the plain meaning is certainly plain. It's like saying black is white, white is black. Either it's contiguous or it's not. If the legislature wanted to allow for,
Is
Well,
it ambiguous? Is the term
I don't
ambiguous?
believe, I don't see how you can say contiguous and ambiguous, quite frankly. It means touching. Contiguous means you've got to be touching, you have to be abutting. These lots do not abut. I understand the problem and the concept that they're just divided by a road, but the legislature clearly made clear that it might be contiguous, that they have to be contiguous. And the fact that it might be divided by a road is an issue because you got people crossing the road, you get more traffic. There's
Mr. Stevens, was the road titled to the town or was that a right of way?
It's not, yeah, the town owns the fee simple interest of the road. The surveys show that the lots are totally separate. So, I mean, I understand that that basically the judiciary wants to make a stretch for affordable housing projects. I understand that,
Well, that's
but it's
that's not what we're,
I don't think we want to make a stretch for
well,
anyone.
and I'm just saying, I think it's a stretch to say that that's somehow ambiguous. And I'll sort of let you go question the other side first, I'll come back.
all right.
Well, I have one quick question regarding the trial court seemed to put a lot of stress on construing that word broadly, based on the policy before the housing statute that we're talking about. And what's your position regarding a broad interpretation,
Of what,
the broad interpretation of contiguous?
well, again, you can look at any definition for contiguous, and it means contiguous means touching. You don't get to, I don't think you get to interpret, quite frankly.
Okay. We'll hear from counsel for one of the appellees, please. And for the record, if you would introduce yourself, identify your client.
Thank you, Mr. Chief Justice, and may it please the court. Matthew Greer on behalf of Windham and Windsor Housing Trust.
Thank you.
The decision below was correct because this mixed income residential development is a priority housing project that is exempt from Act 250 review because the parcels at issue are separated only by a low-speed Class 3 town road, and they function as a single tract. So for purposes of Section 600135, they are contiguous. And that interpretation of the contiguity requirement is consistent with the text of the statute, with this court's precedent, with the legislative intent behind the priority housing project exemption, and with common sense. And I'd like to start addressing directly my friend's argument, which I understand to be contiguity can only mean touching, and the fact that there's a Class 3 town road between these parcels means that they're not touching. And that's wrong for two main reasons. First, as a matter of just dictionary definitions, contiguity can bear more than one meaning. The NRB's brief at page 10 cites dictionary definitions that define contiguity as in close proximity. And Justice Carroll, as you identified, this court's decision in Route 4 Associates did not purport to adopt one definition of contiguous for all statutes and for all time. Instead, the court recognized that that word is going to mean different things in different contexts. And in fact, the Route 4 Associates court cited cases for the proposition that a public road running between two parcels does not break contiguity. And that's really all you need to resolve this case. It's enough for this court to say that a public road running between two parcels does not break contiguity for purposes of the priority housing project exemption. But it also—
So we wouldn't need to overrule Route 4 if we could just interpret Route 4 to say that this is included within the broad scope that's provided in that case.
That's exactly right, Justice Cohen. A decision in this case saying that a Class 3 town road does not break contiguity is perfectly consistent with Route 4 Associates, which was interpreting the town of Sherborne's zoning regulations anyway, and explicitly recognized that contiguous is going to mean, or could potentially mean, different things outside of that particular context.
And
But-
so how are we to know what contiguous means in any particular case? If it can have different meanings in different cases.
Well, you start, Justice Heaton, with the text of the statute, right? So a permissible definition of contiguous is that they're in close proximity. So that's the starting point for any analysis of whether two parcels are contiguous. But aside from that, I think Route 4 counsels toward a practical, fact-based approach, because it's going to depend on what the circumstances are on the ground. And I think if I could offer a little bit of context here about the development of the Act 250 exemptions here and the contiguity requirement itself, I think would shed some light on this issue. It's no secret that Vermont faces a housing crisis, and there's been a shortage of housing for some time, which is why over the past 2 decades, the legislature has sought to incentivize construction of new housing units, particularly the affordable housing units that Windham and Windsor Housing Trust is trying to build here. So in 2002, the legislature first created exemptions for mixed income housing developments. But under that regime, if a developer had multiple different projects within a designated area, all of those units would be added together for purposes of triggering the Act 250 review threshold. And that's why in 2008, the legislature further amended that statute and added in this single tract or multiple contiguous tracts language. And the purpose of that, and in 2008, the legislature also said, we're not going to add up all of the developers' projects in a designated area for purposes of the threshold. Instead, we're going to look at discrete projects and count each of those to see whether or not the Act 250 review threshold is triggered. So the purpose of the contiguity requirement to begin with was to distinguish between discrete projects. It was never to discourage them. And the legislature further amended Act 250 in 2014. And that's when it added this priority housing project exemption language as it exists today and instituted jurisdictional caps based on different population centers. So the higher population center, the more units could be built without triggering the Act 250 threshold. And then in 2023, just last year with the Home Act, the legislature lifted the cap on units for priority housing projects generally for the next 3 years. And it allowed up to 24 units of market rate housing to be built if in a designated area, if they're on a tract or tracts of land. So for market rate housing as of last year, there is no contiguity requirement. And so, Justice Heaton, I think the development of the contiguity requirement and the progressive relaxation of the Act 250 review for this type of project counsels in favor of taking a fact-based approach. And of course, there are going to be multiple factors in whether a project meets that definition of contiguous. And I think as a matter of common sense, this project exemplifies the type of project that is contiguous.
Do we need to decide here whether this is a single tract or whether there are multiple contiguous tracts?
So this is a single tract by virtue of Act 250 Rule 2C12, which defines a tract based on common ownership. So it's that definition of a tract of land is one or more physically contiguous parcels of land owned or controlled by the same person or persons. And so whether it's a single tract or multiple contiguous tracts, there's still that same contiguity language that needs to be interpreted.
So the short answer is no, it doesn't matter.
Well, the short answer is it is a single tract, but your analysis is going to be the same regardless. And I'd just like to touch on the common sense reasons why these parcels are contiguous. We've talked about this Class 3 town road. I think my friend called it a highway. Class 3 town road is not a highway. This is a small 25-mile-an-hour street through downtown Putney. It's not a high-speed situation. And there's going to be a crosswalk connecting the overflow parking to the housing units. That crosswalk is going to be paid for and built by Windham and Windsor Housing Trust. The town of Putney treats these parcels as a single parcel for tax purposes. And this was also approved as a planned unit development, which requires parcels to be developed as a single entity. A panel of this court has already affirmed that decision. And so all of those are factors, Justice Eaton, I think, that go into the analysis of whether parcels are contiguous for purposes of the priority housing project exemption. And we submit that they are here. And I'd also like to touch on a perverse consequence of the appellant's position. I mentioned the Home Act passed last year by the legislature. Under that act, 24 units of market rate housing can be built in a designated area with no contiguity requirement. But under the appellant's position, those same 24 units of affordable housing of the kind that Windham and Windsor Housing Trust is trying to build here could not be exempt from Act 250 review unless they are on contiguous lots. And given the severe shortage of housing and the legislature's clear intent to incentivize construction of more housing and more affordable housing, that could not be a result that is consistent with what the legislature intended this exemption to be.
I'm surprised that when the legislature made some modifications, they didn't take out the contiguous language. Doesn't that tell us something?
Well, Justice Carroll, I could guess that that would be an oversight, but I think the legislature understood that the function of a priority housing project exemption in this contiguity language is to distinguish between projects. And if it's working as we think it works, as the environmental division interpreted it below, there was no need to remove that language because you're only looking at whether a project is a discrete project such that those units should be counted for purposes of Act 250 review. If the court has no further questions, we ask you to affirm.
Okay, thank you very much. Let's just, before the co-appellee counsel, come on up, please, counsel. Let's just find out how much time there is left on your side here.
Appellee has 5 minutes, 50 seconds remaining.
Thank you. Please introduce yourself and identify your client.
Thank you, Mr. Chief Justice. Your Honors, may it please the court, I'm Melanie Key, Assistant Attorney General representing the Vermont Natural Resources Board.
Thank you. And you know, there's a button there you can lift, apparently you can raise and lower that. Oh, yeah.
Wow.
I like that. That's good. You knew what you were doing. I'm glad to see that. Thanks.
The Environmental Division correctly decided that the proposed housing project is exempt as a priority housing project. The purpose of this Act 250 exemption is to incentivize affordable housing and other smart growth development in Vermont's designated centers, which have robust planning and zoning. The narrow interpretation proposed by appellants that contiguous requires touching would frustrate that goal. As the court below stated, this proposed development is precisely the type of housing development the legislature sought to encourage by adopting the priority housing project exemption. It is undisputed that it's a discrete project located entirely within a state designated center pursuant to Chapter 76A, a neighborhood development area planned by the town and approved by the state for housing development. It is also undisputed that the project exceeds affordability requirements in the statute. It has approximately 76% of its units will be affordable, well in excess of the 20% required by statute. The lots in question are part of a single tax parcel under common ownership, permitted as a single planned residential development, and function as a single compact walkable housing development consistent with smart growth principles.
And counsel, I hate to interrupt you here, but are you suggesting that the benefits of this project suggest a different reading of what is single parcel or contiguous?
Yes, Your Honor, when read in light of the statutory purpose. Thank you. This project exemplifies the type of development the legislature wanted to incentivize. There's no reason to read the statute narrowly, as appellant suggests. Touching is not the only meaning of the word contiguous. As the court noted in Route 4 Associates, contiguous does not always require touching, where a broader interpretation is supported by legislative intent. That is the case here. In Route 4 Associates, the question was whether lots separated by privately owned land were contiguous under the Sherburne PUD regulations. Although the zoning regulations themselves actually provided for use of the dictionary definition for undefined terms, the court did not rely solely on the dictionary and looked to the purpose of the enabling statute. which was to permit development on large parcels of land, so larger lot size in that case was key. It also applied common sense in harmony with that purpose and read the statute accordingly.
So do you agree with the trial court that it should be broadly interpreted?
Yes, Your Honor,
And why is that?
because it's consistent with the purpose of the exemption from Act 250 to incentivize this type of housing development in our state designated centers, which provide some level of environmental review through local zoning that the state has approved as being rigorous enough to meet the designation requirements under Chapter 76A.
It seems to me that all the discussion about us, the court considering and everyone considering the intent of the legislature, kind of borders on an argument that this is ambiguous, that the word contiguous is ambiguous. Do you think it's ambiguous? Because that's usually when we dive deeper into legislative intent. So are we doing that, or are we to rule that it's not ambiguous, but we still consider legislative intent?
Your Honor, I believe in Route 4, the court did not make a separate conclusion that the term contiguous was ambiguous, but rather read it in light of the statutory intent. Whether you do it that way or find both susceptible to two meanings, it could mean touching, the primary meaning, can also mean near or close to. And in that sense, analytically, it crosses the threshold into ambiguity and then you reach legislative intent. The result, we believe, is the same. The court's approach in Route 4, looking beyond the dictionary to statutory purpose, makes sense here and supports a broader interpretation. A narrow reading would undercut the legislative intent to encourage affordable housing in designated centers. Moreover, to respond to a question Justice Wade was asked earlier about the town's grand list treatment of the parcel as a single parcel, just wanted to note for the court that the word contiguous is in that statute as well. 32 VSA 4152, parcel means all contiguous land in the same ownership together with all improvements thereon. While that statute is not binding here in the Act 250 context, it may be instructive. In conclusion, applying the broader definition is consistent with the statutory intent and the goals of promoting compact, affordable housing development in state designated centers while protecting the environment. We ask that the court affirm. Thank you.
Thank you very much. How much time does the appellant have, please?
Appellant has 8 minutes, 51 seconds remaining.
Counsel.
Thank you, Your Honors. I hope it doesn't take that much longer, but in any event,
It's up to you.
okay. Maybe I'm a little confused. Like, there's an old term called black letter law, and I used to think that came from Black's Law Dictionary. And Black's Law Dictionary defines touching at a point that contiguous means touching at a point along the common boundary. These two lots are not touching along the common boundary. And the fact of the matter is that no one's asking them to stop the project. We're just asking for Act 250 review.
So let me interrupt you there. From your client's point of view, what would be the benefit of what do you anticipate the benefit of Act 250 review would be here?
We're concerned about traffic. One, this road is actually a 35-mile-an-hour. We go through, you get off the interstate and you go up to the co-op, come down Hallway Drive. It's a 35-mile-an-hour drive. It's one-way street to get back to the interstate. So it has quite a bit of traffic. Two is you've got a question about aesthetics. And three is you've got a question about whether there's ag use on this land. I mean, there's a current gardening and all that. They may be taking care of that issue. But these are issues that get brought up by Act 250. And it's not a lot to ask to jump through that. And the fact of the matter is they don't meet the hurdle. A single track or contiguous lots.
Isn't there, though, a presumption in the law in favor of construing land use regulation to the benefit of the landowner? And wouldn't that be something we would take into account here? Vitale is the case.
Yes, because it's a restriction on
Yeah.
free use of land, yes, you can construe it, but again, I just don't know, quite frankly, how honestly you get to the question of what contiguous means when it's plain. And you normally don't go and look at legislative intent until if there, only when there's ambiguity, no plain meaning. And here contiguous is clearly plain, but that's up for you to decide. Thank you.
Okay. Thank you both. Please,